Thank you, Brian.
Okay.
I call the Honourable Philip Heatley.
Speaker, I too rise to support Damien O'Connor's legislation in this third reading. Andrew Williams, while giving a reasonable address, it was a little bit simplistic, and I would like to lay out a bit more detail as to what we're doing here in this legislation. So, backed by popular demand, and the House has required or asked me if I will do this, I will just lay out a bit more of the detail and undercurrent that's happening in this legislation for the general public. Essentially, though, in summary, this bill is needed to validate certain rates set incorrectly during the period 2003 through to 2009. It wasn't just about a map, a physical map being sent out to ratepayers as part of the consultation period, or lack thereof of a map, that brought about the incorrect setting of rates in the district, although that, as I acknowledge, was part of it. In fact, certain rates, and a large number of them, over those annual periods between 2003 and 2009, there was a large number of rates set incorrectly, not those ones just in relation to that smaller area in the Tasman. And without validation, without this legislation, the Council remains very vulnerable to legal challenge from ratepayers over the incorrectly set rates. And court action, of course, would result in further ratepayers' money being spent by the Council in its defence, and individual ratepayers taking the Council to court will, of course, again end up adding to the burden, the financial burden to those individuals who rightly bring a challenge, because even this Parliament has established that those rates were set incorrectly. So validation is also required to allow the Council to recover all unpaid rates and penalties, something that we considered in depth. Some residents have objected to details of the stormwater rate. They were not properly consulted on the urban drainage area and are being charged for stormwater services they are not using, and that is what Andrew Williams was directly referring to when he talked about the map not being sent out. But Damien O'Connor, the bill's sponsor, has discussed their concerns, is convinced himself that the Select Committee will provide residents with an opportunity to express their views and for any appropriate changes to be made. And that's what he assured himself would happen. This is what happened. The Select Committee did consider the concerns of residents, and we landed in a place, while not ideal, because this Parliament, as a general rule, does not like retrospective legislation, but we did land in a place where we believe the right decisions have been made. So Damien O'Connor can be assured that the Select Committee did listen to ratepayers and the electorate that he represents. We heard from them. They put through sound arguments. We took on board many of their suggestions, but unfortunately not all of them. So National does want to give affected ratepayers and residents the opportunity to engage. We did, and we supported this bill to Select Committee, took it through that process, and we're now on the third reading. It should be noted at a higher level that a key part of National's better local government reforms is monitoring and improving council performance. Publicity about the bill will show other councils that their own processes may come under greater scrutiny, and so they should. The reality is that far too often we see across New Zealand rate increases or increases in development levies or whatever the charges may be. The decisions on that, the decision makers not being held to account. And the need for this legislation just goes to show what can go wrong if councillors, if decision makers within council aren't held to account. So the bill will validate rates set by Tasman District Council from the period 2003 through to 2009. One of the big issues here, of course, is that in each of those years, individual rates were passed through council processes, and the rate charges are sent out on that annual rate demand. And by way of example, in 2003-4, and this is where I get down into the detail which I'm so familiar of, and I share it with the House, is that in the 2003-4 year, by way of an example, is that the Tasman District Council resolved that the general rate and uniform annual general charge be adopted, that the Motueka business rate be approved, that the Richmond business rate be increased, that the council adopt a community facilities rate for that year as well. And as it so happened, the resolutions did not comply with sections of the Local Government Rating Act 2002. The council had to state clearly that they were setting rates as required by the section. They didn't. They had to refer to all of the rates that were purported to be set when they did it. They only actually referred specifically to those ones that I read out and a couple of others. The council did not set the rates before it had resolved to adopt the annual plan, and it failed to state the financial year to which the rates applied, which is an unusual oversight, I must see. They failed to say that the rates could be paid by instalments, which of course is usual right across New Zealand, and they failed to resolve that that you could authorise penalties to be added to rates which weren't paid by the due date. And that is just the 2003-04 year. And as members here are clamouring to hear about, well, what happened in other years, I will go over the 2004 and 2000, and if members in the House, don't worry, I will come to it, the 2004-2005 rates, how they were set. Well, in that year, the special council meeting did in fact resolve that the charges, including the uniform annual general charge and targeted rates, be adopted. That the Tasman District Council set rates under the Act for the financial year. They did a detailed impact statement. Except for metered water rates, the council said they would invoice rates quarterly, so that's good. That the council adopt its long-term council community plan. The council did all those things, but unfortunately the council did not comply with section 23 of the Act by purporting to set the rates before the council again had resolved to adopt the long-term community plan. So they made that mistake again. They failed to resolve to authorise that penalties be added. Again, they made that error, which of course leads me to the year 2005-2006, which I think members are most interested in. If I can gauge the interest of the House here, members are most interested in what happened in 2005-2006. Well, at the council meeting that resolved issues around rates in 2005-2006, and incidentally that occurred on the 24th of June 2005, for those members who want to just take a note of that, it was on the 24th of June 2005, the council said that the refuse recycling rate be adopted, that the general rate increase, that the uniform annual general charge for that financial year be set at, incidentally, $160, that targeted rates be set, and so on. But unfortunately, once again, they did not state clearly that the council was setting rates as required by the Act. They did not refer to all of the rates that they meant to have set, just cherry-picked, if you like, and they did not resolve to adopt the annual plan before they set the rates. And once again, they did not name the financial year to which the rates applied, and they did not say that they could be paid in instalments, and once again they did not include the provisions around penalties. Very disappointing. That brings us to a point in the third reading where we simply have to, as a parliament, support the passing of this bill to resolve what were serious mistakes by the council at that time.
I call the Honourable Mary Ann Street.
Thank you very much, Mr. Speaker.